announcements and presentations, there are none. And public comments. Did the recording secretary want to announce public comments, or would you like me to? Okay. Members of the public are invited to address the Oversight Board on issues that are within the Oversight Board's purview and not on the agenda. Each speaker is allowed 3 minutes, and we have one speaker on item 6, Mr. Kidwai.
I begin in the name of God who is beneficial, most merciful. My name is Nick Iqbal Kidwai, resident of Newberry Park since '79 and opponent of the redevelopment agency since '93 and a director of the Concerned Citizens since that time. Since you folks are like the city council and never answer, I will still be stupid enough to ask and say that I would like somebody on the dais to make a motion to allow 5 minutes. It's really disgusting. Nobody's here anyway, but for those of us that try to come here and take time out of our working day to, and since these are weighty issues and we're talking about millions of dollars, to not allow 5 minutes is disgusting. You folks did not listen to my comments and approve the ROPS with the 4 items that were completely disingenuous, had no backing, and I'm glad that you have accepted them, and I hope that there would be no one stupid enough or foolish enough to waste taxpayers' money to seek legal redress, because there's none. The disappointing thing is, and I'm happy to hear Mr. Dursey talk about that your role is the dissolution of the RDA, not to keep it going like the city manager had said in the 1-hour dissertation. There are 3 items that the State Controller's Office and even Governor Brown's office is looking at now, because they're not on the ROPS, but they were the sneaky attempt of the city to take money from the redevelopment agency fund and transfer it. One is $2 million to the Thousand Oaks Mall as a grant, $6.2 million for parking, $5 million approximately to buy 3 lots next door, and then you dug your own grave by amending the DDA on the private side with Mr. Caruso. None of these actions are allowed under AB 27x1 from August to 11, and because of that reason, these things will be struck down, and they are taking their time. They have not said no. It doesn't mean that they're not to do it. But somebody in the dais, especially the public rep, I mean, I don't know who you're representing, should ask that these be brought back, and so that the money should be returned to the legitimate residents of the state of California, including the college district, the school district, the courts, and not wasted on people like Caruso for $1 a year. And I feel really sorry for those people in the agency that will have to leave the jobs. I implore the city manager to find them jobs in other departments. Thank you.
Thank you, Mr. Kidwai. All right, action items, Oversight Board, legal representation qualifications, and the report will be done by Assistant City Attorney Chris Norman.
Good afternoon, and thank you, Madam Chair and members of the board. At the last meeting, the Oversight Board directed staff to provide the qualifications of an attorney to provide legal representation to the Oversight Board. After diligent inquiry, staff is recommending Joseph Fletcher to serve as Oversight Board legal counsel. Mr. Fletcher has almost 30 years of experience in municipal law and redevelopment. He currently serves as city attorney for the city of Ojai, served as city attorney for the city of Santa Ana for 14 years, and the city attorney of Burbank for 6 years. Mr. Fletcher is seated next to Mr. Mitnick, and staff and Mr. Fletcher are available for questions. Staff is recommending that you appoint Mr. Fletcher as legal counsel and authorize successor agency staff to enter into a retainer agreement with him. Thank you.
Do we have questions of staff?
Maybe just, if Mr. Fletcher's here, if you could introduce himself and give just a brief background on the redevelopment experience.
It's a pleasure to be here. Yeah, I've spent 27 years as a staff attorney in local government, Modesto, Anaheim, Burbank, and Santa Ana. And both in Burbank as a staff attorney, originally I went as a redevelopment counsel, and then continued to do that as city attorney. And then during my 14 years as city attorney in Santa Ana, also deeply involved in redevelopment. Done both transactional work. I've got a fair amount of bond experience as part of that, and as well as all the other legal issues that arise from redevelopment law. I'm city attorney of Ojai, and there, of course, we're dealing with the issue as a successor agency. So I deal with those issues there. I'm also I just received the appointment of city attorney of Menifee out in Riverside County. I was involved in redevelopment, 2 or 3 amendments to the redevelopment law back. So I've seen the evolutions of the RDA law and the rules of RDAs.
I have one question.
Sure.
We have your resume.
Mm-hmm.
Have you ever been employed by the city of Thousand Oaks before?
No. Sure.
Anybody like to make a motion? Mr.
I'll
Watkins?
move the staff recommendation.
I'll second it.
Vote please. Aye.
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 Thank you.
Right, informational items. Item 8, John Prescott is going to present a Department of Finance recognized obligation payment schedule approval letter. Mr. Prescott?
Thank you, Chair Irwin. We did distribute this by email shortly after we received it to the board, but just for your formal information, we included a copy of the letter that we received from the Department of Finance in response to our recognized obligation payment schedules, both for the January, June, and July, December 2012 periods that have been approved by the Oversight Board at your last meeting. And as you can tell, the state objected to 4 of the line items. At this point, we're not asking the Oversight Board to do anything regarding that. I would point out that all of the obligations that the agency actually needed to make payments on were approved by the Department of Finance, so there was no interruption in actual payments out. Also, there is the redevelopment trailer bill. We just received word that passed the House and the Assembly earlier today. That has a provision in it that will require us to bring the next drops for the first half of 2013. Probably need to bring it to the Oversight Board at your second meeting in July. I think we need to adopt that by and send it up to DOF by September 1st. So at that point, either we will continue to show these items that they objected to on the ROPS for that period, if we can develop better justification, or in looking at the law, if there's anything in the law that helps us buttress our case that those are actually enforceable obligations, then we'll continue to include them. And also, as we indicate in the report, this is a very dynamic time for redevelopment law, and I'm not certain that there would be any other legislative changes, but we do keep the door open in case there are legal challenges that might be beneficial to us. So at this point, the board does not need to do anything with the ROPS. We're just providing the DOF letter as information. I would note, however, that one of the items that we did have on the ROPS was the Auto Mall parking project, and that was upheld by the DOF as a legitimate enforceable obligation.
All right, and are you going to also present item B?
Mr. Hatcher is.
All right, and that's the successor agency asset inventory.
Right.
Mr. Mitnick, did you have?
Yeah, you know, before we leave this item, John mentioned, it's okay, Chair, John mentioned the trailer bills today, and we've been on the phone this morning, and the AB 1484 did pass the Assembly and the Senate. it appears that our bond proceeds are gonna be protected. We still have to go through, figure out what that means. But there's some provisions in there, as we understand it, we're just digesting it, that gives this, the Department of Finance a lot of teeth to do certain other things. So we may have approximately $15 million of bond proceeds that are protected. So we just don't know, but that's what it looks like.
Thank you, Mr. Mitnick. Mr. Hatcher?
Thank you, Madam Chair, board members. You should have in front of you on the dais a color booklet, and that was included in your packet as a black and white document without the color pictures. And basically what that is an inventory of the former redevelopment agency assets. And we're providing it to you at this point in time as an information item, so that you have time to familiarize yourself with these items. And basically it's broken out into 3 different categories, and those are land, and then buildings and tenant improvements, and then lastly infrastructure. So obviously the land is holdings of the agency that will need to be dealt with at some point in time in terms of how they're disposed of. The tenant improvements and buildings are investments that the agency has made over time in existing structures that it may or may not own. And then lastly, the category of infrastructure improvements contains a number of public improvements that have been paid for by the redevelopment agency, and most of which are existing on city property but are still retained on the books of the agency as an asset. So again, this is just intended to be an inventory of these assets for you to have an opportunity to familiarize yourself. And what we would intend to do at future meetings is to bring these assets forward with recommendations on disposition. And I'll be happy to answer any questions if you have any.
Do we have questions? Mr. Dorsey?
The asset of cash, what is the status of the cash relative to the low-mod housing and these, your overall RDA?
I'm going to defer that question. We don't have our finance director with us.
That's fine, I can just send me, just curious more or less, just wondering. I know that the state is concerned about getting the cash sooner rather than later, obviously, and that, is there enough increment to pay, coming in to pay the ROPS without needing the cash? I guess that would.
Yeah, the answer is yes.
Yes.
Do you have any other questions? All right, and then our, thank you, Mr. Hatcher. Our third item is the legislative update, and that's a verbal report. Is that Mr. Prescott, or?
Well, I'll take a stab at it, and if others, Mr. Mitnick or Mr. Norman, wish to chime in, they can. But the, you know, there have been several bills that have been introduced that we're moving very slowly regarding redevelopment. And the reason that we're moving slowly is that the budget trailer bill is being developed, and on Monday, the text of that bill was released and by the budget committee that was assigned to it. It's moved through now both houses of the legislature and been approved by both houses, so it'll go to the governor for signature. And that really took what they wanted to out of the other bills, and the other bills became things unrelated to redevelopment, or at least to the workings of successor agencies and oversight boards going forward. So the bill is AB 1484. It's 73 pages long, and we are going through it line by line to see the exact changes that are made. But there will be, I pointed out one of the changes in terms of us bringing that next ROPS to you earlier than we would have otherwise. There are other provisions that I think strengthen DOF's position, giving them some explicit authority to hire their own lawyers and experts, et cetera, and also giving them more time to react to the items that the Oversight Board sends up to DOF. Or that the successor agency sends to DOF after Oversight Board approval. We are also now will be required to include the county auditor controller, CAO, and DOF when we submit certain documents. We'll also have to DOF will also have to submit them to those county agencies, and prior to submitting them to the Oversight Board. We're reviewing. There's a lot of language relating to the definition of housing assets. One of the controversies and inconsistencies in AB 1X26 was in two different sections. One implied the agency could keep the housing cash in the low mod housing fund, and the other one said it couldn't. They had to transfer that to the auditor controller. So they've kind of approached that by 2 or 3 pages of definitions of what housing assets are. And so far I haven't found our checking account in there, so we may still, I think that was the intent, that they want to keep that cash. There's other assets such as loans that the agency has made of low mod housing money. For example, an affordable housing project where they're paying that money back. And then I think those kind of loans are counted as assets that we can keep and keep the income stream from them. So those are kind of my initial comments. There's procedural things when we bring forward the asset list. And I think at the end, we will need to provide an accounting of all the remaining assets and their values and the cash on hand, and that'll have to come before the Oversight Board before being submitted to DOF and the county auditor controller. So kind of when we've gone through disposing of the assets we can and kind of what's left, and after enforceable obligations are taken out, then they're going to want an accounting of all of that and be approved by the Oversight Board, and then at the end of the day, a remittance to the auditor controllers. It kind of spells out those procedures that aren't in the original AB 1X26. I don't know whether either Scott or Chris had additional comments. We saw the bill for the first time, although there have been reports coming out from the League of Cities from their discussions with legislatures of some of the principal provisions, but we saw it for the first time late Monday, and so we've been looking at it the last couple of days.
I can add that since our transactions are pretty straightforward, we don't have any city agency loans or agreements to worry about. We had 2 bond issues that were done well before the time restrictions that were done back in 2002, 2005, and our projects are pretty clearly delineated. I think we're in pretty decent shape based on the first read of this with respect to the bond proceeds. So it's possible that I looked at it, I added up the numbers, the Thousand Oaks Boulevard utilities undergrounding, it's either 10 or 13 million, I have to figure that out. And then the Kelly Road improvements is 3.8 million, so anywhere from 14 to 18 million dollars may be okay. And I know if Dr. Barstow were here, he'd be pleased to hear that. So we're trying to get clarity on that. And John walked in. John, in terms of the
Get to work.
is the bond proceeds for the boulevard, is it 10.4 million or is it 13.9? Do you know off the top of your head?
It's not the 13, the 13 was for the full project.
For the full project, so it's 10.4. So then the total is $14.2 million may be protected. And then that leaves the delta in terms of capital money, that would have to be remitted to the state. If I understand this correctly. We'll get more clarity as our lobbyists in the league are able to go through and explain to us what the legislation means.
So they removed the criteria that there has to be a contract?
Well, the contract is the bond covenants. Yeah, the official statement, the bond, what they told us.
That's changed.
Yeah, they're going back to what the Department of Finance told us on April 9th, when the finance director and I went up there, and they said your bond proceeds are good, those are enforceable obligations. They're gonna go back to that.
Do we have questions of staff?
I have one question. You know the status of your audit of your ops?
Audit from the higher.
Auditor, controller, or whoever they're contracting with?
Correct. Just a little bit of history for the board. Part of the auditor controller was tasked with hiring an auditor. The auditor that was selected by the County of Ventura was Brown and Associates. They came in, they have an agreed upon procedures, was a list of items that they were supposed to go through. That audit draft report was submitted to us last week. We provided management comments on yesterday, actually. We should probably have that finalized. We'll see another draft probably tomorrow or Thursday, and it will probably be finalized, I think by July 1st, I think is the hope. In addition to that, our internal auditors are finalizing the financial audit as of January 31st, 2012, and that's in final draft, and it's just waiting for final review by the auditors. So, just for maybe some information for the overall, I think there was, they had like 25 items. There was a couple quote-unquote findings. Management, myself, responded with those findings. Things like when the ROS was actually approved by the board. As you know, the legislation required it to be approved, I think, April 15th. First meeting for the Oversight Board wasn't until April 25th, and so that was one of their findings, but our response was accordingly. Oversight Board wasn't meet till the 25th, and then it was adopted on the 9th, so we'll provide that, I guess we'll provide that report to the Oversight Board once it's completed. But that report is supposed to be conducted by the auditor controller, and I think sent up to the state controller's office, if I'm not mistaken.
Anything else? All right, any board comments? Okay, then we are going to adjourn to July 11th, 2012. Thank you, everybody.